This is a good question that was asked, and it says, what are the implications on educational institutions, both secondary and higher, that receive federal funding who discriminate either on employment or admissions toward individuals of same-sex lifestyles, now that the federal government recognizes this as a viable form of marriage in 13 states?
Well, that's one of the many issues we don't know an answer to that. That will be determined with future litigation. It's hard to speculate as to how. I think you may even see differences in interpretation by different federal courts with regard to an issue like that. But there's not a definitive answer to that based on the Supreme Court's DOMA decision, unfortunately.
Okay, well, that's a great question. Unfortunately, I know we're getting we're basically out of time. Is there anything else that you wanted to share?
Well, yeah, I do. I want to share one more issue, which is I get this all the time. Do we need to amend our church bylaws to define marriage as a union between a man and a woman? I'm not opposed to doing so. If you want to do it, go ahead. But my church hasn't done so. And I just want to make some comments here in closing. Like I said, no court in the 237-year history of our country has found a minister liable, civilly or criminally, for refusing to perform a marriage contrary to his or her religious beliefs. Many church bylaws that I've read already are broad enough to embrace strong provisions of scriptural authority that would be enough to I think, give you the flexibility to make that decision on your own without an explicit definition. Another point is the bylaws are not a place to be defining marriage. I mean, if you want to have a policy manual, okay, but bylaws are the rules of governance and administration of your church. And this kind of thing, to me, is just out of place in a church's bylaws. Let's see. So anyway, the bottom line is this. I'll be monitoring this, Jerry, and when I start seeing even the first case attempting to sue a minister or church for refusing to perform a same-sex marriage that is or is not valid under state law, believe me, I'm on top of it. I'll be monitoring. And if there's a need for counsel, if there's a need for warning, I'll be the first person to do it. But I also say this, that I don't know that a provision in your bylaws defining marriage as a union between a male or female would even work. A court could ignore it. And as I said, you can prove your doctrinal position by testimony. You don't have to have a provision in your bylaws necessarily to do that.
We always try to be cutting edge, and we try to, the 2 Supreme Court rulings happened, we answered it. FEMA just came out with some recommendations for churches and how they should respond to emergencies, and that just came out. And I think that's what we're going to try to talk about next time, is FEMA's response and whether or not what our response will be to FEMA based on their decision. So join us next time for Risk Management Live when we talk about the FEMA's responses for churches to respond to emergencies. So we'll see you next time. Thank you.